Well, I've got 6 o'clock and I like to start on time. And so I'm glad that you're here with us. Again, my name is John Walker. It is an absolute privilege to be with you and to host this webinar on behalf of Superior School of Real Estate. I've been with Superior now for several years. It's been such an honor to work with this company. One of our commitments as a company is not only to provide outstanding classes in terms of pre-licensing, post-licensing, continuing education, and those things. We also want to be a resource for you in the industry at large, and that's what this webinar is all about tonight, is trying to provide a bit of clarity around a very hot topic in our industry, and that is the NAR settlement that has been recently announced and is still being worked out in real time. But I know a lot of brokers have questions about this. We can't give you every answer tonight, but we do hope to provide at least some basic information and give you some hopefully some clarity around what's happening. Let me start off just by giving you first of all, thank you for being here. We know your time is valuable. We value that you're here, and we want this time to be a benefit to you. Let me share an important disclaimer. And I am not an attorney. This is an informational discussion. It's not a legal analysis. I like to think sometimes that I could practice law. I never got a law degree, so I'm out on that discussion, unfortunately. But anything you hear presented tonight is strictly a version of us passing along factual information that's out there, some information that NAR has provided to provide some clarity around their kind of side of this story, and also some public releases. Everything that I share is strictly my opinion only, and Superior is not liable for what I have to say here, but nothing shared here is meant to be legal or business advice. So just kind of know that going in. And I want you to feel comfortable and casual. Those of you who I have had in the class before, you know I'm about as easygoing as it gets, but we're talking about a pretty serious topic here. And so I want you to know I take this with the utmost care and seriousness that it is due. But I also want you to feel comfortable and casual, and feel free to write any questions that you may have into the Q&A, and we'll try to address anything that we can as time goes along. Where are we going to go for the rest of our time? I want to give you a bit of very quick background about how we got here in terms of this NAR settlement, and then provide you with just straight on facts about the settlement itself. There's so much misinformation out there about this settlement. We want to give you the facts. Who does it impact? What does it require? And where is that potentially going to lead us next? Number three, we've typed out a few common questions that we've been receiving on our end. We've been getting lots of questions from students or members of our company, members who are our regular CE membership crew. We've been getting a lot of questions. So we've tried to summarize some of those questions for you and some of the more common ones, but then we want to open it up for your questions at the end. Let me go ahead and tell you a bit of a challenge for me on this. When the Q&A starts flooding with questions, I will do my very best to go back and scroll through, but I may not get to those questions till the very end. So if you ask a question, please don't panic. I will try to get to it and read it. But I will tell you, I typically do not stop in the middle unless Frank or one of the other moderators flags me down and says, hey, we got a question about what you just said. Can you expound on X? And then I'll be happy to dive in on that topic. But for the most part, we'll stick to the script until the end and then open it up for questions. So hopefully that works for you, and we'll have a successful session together. Let's talk about background first. Oh, actually, sorry, I forgot I threw this slide in here. If you need to stay connected with me, please feel free to do so. Again, my name is John Walker. I'm a DREI instructor with Superior. It's a real privilege to be associated with this great company. You know, Bill Gallagher, it's many of you, if not all of you, know who Bill is. Bill roped me into this game many years ago. He was kind enough to give a kid a chance, and I've been honored to be associated with him ever since. And so I want to thank Bill for the opportunity to be a part of this great company. If you need to email me outside of this, please feel free to reach out to consultingjohnwalker@gmail.com is probably the easiest way. If you're into Instagram, you can follow me at Real Estate Instructor, although I don't ever post anything. One of these days I may get around to actually doing that, so forgive me for not being very active on that platform. But one of my first mentors in real estate 20 years ago said something that I never forgot. And he said, I want you to write this down, and I want you to remember this, because this is going to be the heartbeat of the real estate industry for you for the remainder of your time in the industry. And he said very simply, things have changed, things are changing and things will continue to change. If you understand how the real estate industry works, you need to understand the parameters of change, because this is an industry that will shift and turn and do 360s, and it may do it all in 1 year. Now, there are seasons where those changes seem small. There are seasons where those changes seem seismic in their nature. This settlement that NAR has entered into and several other real estate companies has felt seismic for a lot of the brokerage community. That's why you're here tonight, I imagine, because you think this is a big deal. And I don't want to change your mind on that. I agree. It is a big deal. It is a change. It's a shift in the industry, potentially. And it offers us the opportunity to analyze freshly how we got here and where the next steps will be should this settlement go to final approval later this year, which we haven't gotten there yet, by the way, and we'll cover that. So why are things changing now? Let's talk about how we got to the place where we entered into a settlement. We didn't start with a settlement. We actually started with a lawsuit. The lawsuit, commonly known as Sitz or Burn It, was filed in Missouri in 2019. What the whole lawsuit centered around, it was a case that challenged the commission structure where sellers paid the commissions to a buyer's agent, and the corresponding nature that that commission was advertised in our MLS systems. And the reason why that's relevant is because our MLS systems were a membership-based system that was attached to the National Association of Realtors. So the thinking was, according to the lawsuit, was that sellers had no options as it related to commissions being paid. Common question that was raised was, if I'm a seller, why should I be paying the commissions to someone who is actively against my interest? And what I mean by that is, if a buyer's agent is working for their buyer to get their buyer the best price, the best terms, to negotiate things like repairs, why as a seller should I be forced into paying that individual? That was what part of the lawsuit alleged. Now, I used charged language in that accusation because that's how the accusations came across. You and I both know that that's not the full picture. That's not the full reality of what's happened over the last several decades, but that's how this lawsuit was largely presented. And it resulted in a jury ultimately ruling in favor of the plaintiffs for $1.78 billion to be paid in damages. Now, that $1.78 billion was to be broken up amongst different entities. Primarily, the main defendant that was going to have to come up with the funds was the National Association of Realtors, although they were not alone in that. That jury verdict resulted in a place where we ended up with a settlement by several different real estate companies that were named in the lawsuit. We will not get into the specifics tonight about those companies, and also the National Association of Realtors. Now, the National Association of Realtors settled in the amount of $418 million to be paid over a 4-year period. A lot of questions arise from the lawsuit. Number one, why does a lawsuit in Missouri impact folks in North Carolina or Florida or California or New York? Valid questions, and we'll cover a bit of that as we get into our information. Number two, have sellers been forced to pay these commissions? It's a question that a lot of brokers have had. And just for context, I'm living this out in real time with you. I'm a firm owner. I have roughly 30 agents under my purview here in Mebane, and my agents have been asking these same questions that many of you have been asking. Or if you are a firm owner or a broker in charge or a provisional broker or a broker, and you're asking, how does my future get impacted by all this? Those are great questions, and they're legitimate to ask. So I empathize with you. I'm in the middle of this with you as someone actively participating in the sales world at large. And so these are all very relevant topics, relevant questions that you have. I'd like for us to start off by going through the facts of the case, the facts of the settlement, excuse me, because The misinformation is largely within the actual facts. Most of the news headlines said things like real estate industry to change forever, gone is the 6% commission, the days are done of the traditional commission model. That was the headlines. Was that factual when those headlines were released? Let's look at the actual facts of the case. Now, these snippets are from a fact sheet that just about everybody on the webinar tonight can probably access through NAR. These are not opinions given by NAR. This is a summary fact sheet that NAR posted to say, all right, we entered into this settlement. Here's what's in the settlement. So you're aware. And if you're a member of NAR, you have access to this. I pulled out snippets of the fact sheet so you can see directly from them what the settlement contains, and hopefully to give some clarity around what the settlement is. Very rarely will I read anything to you. I'm not wired to read things. I will read this paragraph because I think it's relevant to give us a nutshell for what the settlement entailed. NAR and plaintiffs have reached a proposed settlement agreement that would end litigation of claims brought on behalf of home sellers related to broker commissions. The agreement would resolve claims against NAR, over 1 million NAR members, all state and territorial and local realtor associations, all association-owned MLS systems, and all brokerages with an NAR member as principal that had a residential transaction volume in 2022 of $2 billion or below. The settlement is subject to court approval. Now, you'll notice that that is underlined because that is a critical fact to take away from tonight. This has not reached final approval. I'm going to say that one more time. This settlement has not reached final approval. And depending on who you ask with an opinion on the matter, you'll get an answer that will range from it will definitely reach final approval to this will never be finally approved. And I want to be clear tonight that Superior and John Walker is not taking a side on that spectrum of analysis. I do not know if it will be finally approved. If you backed me into a corner and said, give me an answer, will this be approved? I would probably offer you an opinion on it, but I'm not going to do that tonight because the fact is we don't know. We don't know if this will reach final approval. We'll give you a timeline for when it could reach final approval if it's going to reach approval. I'll show you a chart here at the end of the webinar, but we don't know if it's going to be approved. So that's a very important takeaway to think about as we go through this discussion. Let's talk about what the implications are for different parties associated with this settlement. First, we'll start with NAR and realtors. If you're a realtor, this is very relevant to you because the potential liability that you had as a member of the organization was real. They were suing NAR and by extension, NAR's members. So this releases NAR at a national level. It also releases all NAR members at a national level. There are over 1 million of us who are realtors in the country. All state and territorial and local associations. If you're a member of the National Association of Realtors, you are a member of a local association of realtors. I'm a member of the Burlington Alamance County Association of Realtors. It's known as BACAR here in the middle part of our state, a small realtor association. Well, my association, I sit on the board of that association. It's released in this if this gets court approval. That makes me breathe a little sigh of relief because I don't want my board to face potential litigation in the future. If this gets released, that is one of the release points. Now, you may have also noticed that not only are realtors released, MLS systems are released. And there's two different types of MLS systems that are relevant for our discussion. Number one is MLS systems that are owned by the National Association, which is a lot of them. A lot of our MLS systems are actually owned by the National Association of Realtors, which is part of the challenge of the initial lawsuit was by saying, hey, to be a member of this MLS, you had to be a member of NAR, which meant you were boxing out competition and meant that you could have this little internal discussion about your commissions and who was going to pay it and how it was going to be covered. And we, the plaintiffs, i.e. home sellers in Missouri, felt like we were forced into this. And so we're going to go after those MLS controlled systems because that is where this game is being played that we're concerned about. So most of our MLS systems have been and currently are owned by the National Association of Realtors. But that is not the only MLS systems that exist. There are MLS systems that are not members of the National Association of Realtors, but are participants with the National Association of Realtors. Those MLS systems have the option to be released and to enter in as part of this settlement if they so choose. If they don't, they are potentially open to further potential liability. That's up to them to determine whether or not they feel comfortable entering into this agreement and the terms of this agreement, or whether or not they want to go at it on their own. That's up to them, and they have certain action steps that they have to take between now and a certain date to opt in to the settlement terms. So to keep that in mind, that may be relevant for you if you're part of an MLS system that is not owned by the National Association of Realtors. And I can't answer tonight if your system is or is not owned by NAR. This is going to result in some changes of practice according to NAR as it pertains from the settlement. NAR says we were able to retain the right of consumers to continue to have cooperative compensation. What does that mean? That means that consumers can have the seller pay for commissions for not only the listing agent but the buyer agent. Okay, that's what the cooperative compensation says. As an option, so long as they pursue that option off of MLS through negotiation and consultation with real estate professionals. You'll start to take away that this is a major aspect of this settlement, and that is that a lot of what we have done in practice over the years is not changing, but how it's being done and where it's being done and the communications that's taking place will change. And a prime example of that is that commissions for buyer agency to be paid from a seller side cannot be offered through MLS. Not only are they not required to be offered through MLS, you can't do it anymore, according to the settlement, if this gets final approval. NAR has agreed to put in place a new rule prohibiting offers of compensation on the MLS system. That's very point blank. And the change will go into effect in mid-July. Now, if I can offer one opinion, I will offer an opinion at this point. And again, this is strictly a John opinion. I was surprised at the rapid nature of adoption of this new rule. Typically, when you see these kind of lawsuits play out, this will go into effect in mid 2025. That's not the case with this one. This one got settled out a couple weeks ago, and it said we're gonna impact these changes in July of this year, a handful of months before these changes go into effect. That is a short turnaround in terms of the world of settlements. And again, that's an opinion I have, but I was surprised by that, to be candid. Now let's look at how this is going to have further implications for us as members. There's going to be a lot of ways that buyer brokers can be compensated. That hasn't changed. There's nothing changing. Always, buyers and buyer agents had the option to collect commissions in a variety of ways. Fixed commission rates, concessions from the seller, i.e., the seller is offering a buyer agent commission, or a portion of the listing broker's compensation. And we're not limited to those things, as we've always not been limited to those things. But what has changed is using the MLS to communicate those offers of compensation are no longer going to be an option. So compensation would continue to be negotiable. That's another big word to take away from tonight, is negotiable. If you have something of the nature of the compensation being offered, the thought process in the lawsuit was that there was no negotiation available. That's simply not the case. Commissions have always been negotiable, should have always been negotiable, and they will continue to be negotiable going into the future. How does this impact buyers and sellers? Well, in several ways. This is going to potentially alter the way that buyers and sellers think about compensation of real estate brokers in general. Think about it from the seller side, and we've already dealt with this. I'll give you a personal example. We sat down with a seller recently, and the seller said, "I've read a lot about this settlement that NAR entered into." And we said, "Oh, really? What do you think about it?" And the seller said, "Well, The way I interpret it is I don't have to pay a buyer agent, so I don't want to. Well, my response back to them was, dear seller, you never had to pay a buyer agent. Nobody was ever forcing you. Certainly, we would have never forced you to pay a buyer agent. Now, we may have proposed to you the thought process that it may be something you wanted to think through, but it was never forced. I imagine more sellers will think in those terms moving forward. Maybe that levels out. Maybe that's indicative of the market being in the seller's favor still with inventory levels low. Maybe that'll shift. It becomes more of a buyer's market where sellers say, I'll do anything to sell this house. We haven't really been there in a while. At least where I'm at in North Carolina, we have been in a seller's market for quite some time. Buyers may start to think about things a little differently because in the past, buyers at times operated, whether it was by assumption or through something they heard or even something that perhaps was communicated to them, even whether it was correct or incorrect, that it was not paying a buyer's commission was not something they needed to worry about because it would be covered within the transaction, maybe from the seller's side, for instance. Well, buyers may have to start thinking a little differently. And I'll go through an example here in North Carolina, at least. And if you're outside of North Carolina, I'll try to break down how our state works here. But we, for some time, had some things in place where if it was done correctly, the buyer agent could communicate to a buyer, hey, buyer, just a heads up, here's what I expect to make from this transaction. Now, here's where I'm going to seek that compensation. I'm going to seek it first from the seller to see if the seller is willing to cover it. But if the seller won't, I'll be looking to come up with these funds from somewhere else, and the somewhere else is likely you, dear buyer. So our buyer agency agreements, at least in North Carolina, have had that in play for a long time, even if brokers aren't fully aware of that. We'll touch on that at the end. After the new rules go into effect, listing brokers and sellers could continue to offer compensation. They just can't do it in the MLS. So you can imagine broker websites. You can imagine phone calls between brokers. I'm planning to show your listing. I have a buyer, and I'm planning to show your listing. And I call you up and I say, hey, exciting news. I have a buyer that would love to see your property that you recently listed. And you say, great. Bring them on. What time did they want to see that? And I said, well, I'd like to see it at 5 o'clock tomorrow if it'd be possible. No problem. The house is vacant. Should be easy. Nobody has booked a time for 5 o'clock yet. And the follow-up question is going to be, is the seller willing to pay the buyer agency commission? That listing agent is either now going to say yes, and here's the amount that's being offered, or no, they're not. Or they may say, feel free to write that in as a request. The possibilities are kind of endless. You're also going to see a scenario where a buyer calls, same conversation, want to show the house at 5 o'clock tomorrow. Listing agent comes right out and says, awesome, just to let you know, the seller is offering blank to a buyer agent with an acceptable offer. Hopefully you'll bring your buyer. You'll see that scenario play out. What you won't see are any of those conversations taking place on MLS if this settlement reaches final approval. That's what you won't see anymore. You won't see it put into comments on MLS. You won't see it put as a flat percentage or a flat fee or a stated number on MLS. You will not see anything about a buyer agent commission in the form of a seller concession stated on MLS if this settlement goes through to final approval. And we'll have to see, as we said earlier, if that comes into play. I will stop real quick and answer one question or a comment that came up and said that I just received an email from Katie Johnson, their chief legal officer, that there's been preliminary approval has been granted. That is true. That did happen earlier today. Pardon me for fighting some allergies here in North Carolina. That is true. That happened earlier today. That allows the ball to keep moving forward and provides kind of a 60-day period for this opt-in session where outside MLSs or companies that weren't covered automatically in the suit or MLS systems can say, I want to make sure we're a part of this. It does not equate yet to final approval. So just be aware that that does not equal final approval. It's a preliminary approval. We do not anticipate final approval being a thing until potentially November at the earliest, but I'll show you that timeline again at the end. Another change that will not feel like a change for those of you who are in North Carolina is the written agreement aspect of this settlement. NAR has long encouraged its members, they say, to use written agreements because they help consumers understand exactly what services and value will be provided and for how much. Guess what? In North Carolina, that's been the case for a long time. North Carolina is a state that operates as a buyer agency state. Not every state has been like that. Perhaps you're in a state that has not operated with buyer agency or written buyer agency agreements. That's one of the things that is coming out of this settlement that will become pervasive nationwide. Buyers signing an agreement with a buyer agent that says, if I employ you, here's how much I'll pay you, or here's how much I approve of you making from the transaction that I'm involved with. That has not always been the case across the country. Now, if you are located in North Carolina, it has been said, and I'm only repeating what I've heard from other sources, let's say, that a large reason that North Carolina was not involved in this initial lawsuit, like that happened in Missouri, was due to the fact that we had those written buyer agency agreements in place. Those buyer agency agreements have done a good job for a long time of helping spell out between client and agent what the expectations for compensation and services are. So for North Carolinians who practice real estate from a structural standpoint, it may not feel all that different to you in terms of when you review a buyer agency agreement. You may say, this is how we've always discussed compensation with a buyer. We've always gone over with the buyer that if the seller won't cover the compensation, I'm going to be looking at it from somewhere else. And a common example here in North Carolina that's often given is the for sale by owner scenario. For sale by owner is showing a property. It's not on the MLS system. And a buyer calls their agent and said, hey, agent, I saw that there's a for sale by owner in a neighborhood that we're very interested in. I don't know if you're aware of it. And the agent says, I didn't see anything about that yet. And they said, would you show it to us? And the buyer agent says, I'd love to. I'll call them. So the buyer agent calls the for sale by owner property owner on the phone, and they say, I have a buyer interested in your property. I am their buyer agent. I represent their interest, and I am curious, are you willing to pay a commission to an agent like myself if we bring a satisfactory offer and a buyer to buy your property? And the seller says, thanks for the interest in the property. I appreciate it very much. You're free to show it, but we will not pay a buyer agent commission. Under no circumstances will we be paying that to any buyer agent. So the buyer agent calls their buyer up and says, buyer, good news. You can see the property. I won't call it bad news, but it's news. They will not pay my commission. So if you want me involved in this transaction to assist you with the whole process from A to Z, here's what I'm willing to do that for, whatever that is, whether it's a percentage, a flat fee, something of that nature. That's how we've always had to handle for sale by owner situations, at least here in North Carolina. Well, that's kind of how this is going to work on a broader level, if you want an example to take away with you for how this is playing out in real time. Another thing to keep in mind, and this is a question that came up early, is that MLS participants are going to be required to enter into those written agreements with their buyers before touring a home. Right now in North Carolina, you have to have a written agreement before you write an offer to purchase. You can have an oral buyer agency agreement. It actually has to be an agreement. It can't just be a, hey, I'll work with you. You have to come to an express agreement that spells out the terms of the representation, whether it's oral or in writing. But you have to reduce that to writing before you actually write up an offer. That's the current rules that we have in North Carolina. When this takes into effect, you're going to have a written agreement before touring the home. I have yet to see how that may impact our forms, anything of that nature here in our state. That's not for tonight's discussion. But there was a question asked in the Q&A of, will we have to have a separate buyer agency agreement for every home that we show? I cannot give you a definitive answer on that, but what I do feel fairly confident in saying is that you will have to have some type of disclosure for every property you show in writing about what the expected compensation would be for that home should that buyer purchase that property. That could that may potentially come in a number of different forms. It may come in a form of, here's 10 properties we're going to look at today, got all the addresses written down. Here's what we know in terms of compensation and the expectation for compensation for each of the 10 properties and how they differ should you want to engage on that. And it may be a one sheet with different addresses on it. It could be a single sheet for every single property that you potentially tour, what the expectation would be. There's going to be a lot of moving parts as the days go ahead. I've already heard of some companies saying that they've released their documentation for what that's going to look like. Others have said we're holding off for now until we get final approval to see how this is going to play out. What I do feel confident in saying, however, is that it will be in writing before you look at a home in some form. That will be upfront, that in writing aspect of viewing a property. I've mentioned several times a potential timeline for this. This came out from NAR recently. We got preliminary approval today. That did not reach this particular timeline that was inserted into this, but you'll notice that the second bullet point on the top line says late April decision on preliminary approval. That happened. Okay, we got preliminary approval today, as was mentioned very astutely in our Q&A session there. And then what you're going to see is a 60-day kind of window open up for parties to opt in to this, should they want to be included in the protections of the settlement if the settlement reaches final approval. On the July timeline, that's where NAR is to implement practice changes, the changes about written agreements, the changes about not putting things about seller concessions for commissions in MLS, things of that nature. One thing I haven't mentioned, I'll pause at this spot to mention it. I've said several times you can't put seller concessions in MLS. That's not fully accurate. You can't put seller concessions in MLS about commissions to buyer agents. You can put seller concessions in the MLS about like closing costs, for instance. That hasn't changed. But as it relates to buyer agent commissions, that's what we're focused on here. But you'll notice on this timeline that we're not anticipating, if we get final approval, hearing on a final approval until potentially November. And this could stretch out deeper because there's other factors that we don't know if other regulatory bodies are going to get involved in this settlement that have not currently inserted themselves into the settlement discussions. But if all goes according to the timeline that NAR is kind of planning on happening, you'll be looking at a final approval in November with some of these practices already having changed in July. Whether or not this gets final approval or not, you're going to see some practice changes go into effect with organizations that are attached to NAR, like our MLS systems, and like some of the companies that settled, because they don't want to face further litigation whether this gets approved or not. They want to try to answer some of the questions as it pertains to how the commission structures have been playing out for a long time. So that's the proposed timeline. I want to transition real quick before I take any questions, and I'll look at the Q&A. I want to transition to some of the common questions we've received on our end because they may answer some of your questions in advance. We'll burn through these pretty quickly, and then we'll wrap up with the questions that you've typed in. Hopefully what we've said so far has made sense and you're tracking with us on what's taking place with this settlement. So some of the common questions we've received. Number one is, how does this settlement impact my ability to represent clients and negotiate transactions? The short answer to that is it doesn't. You have the same ability as a broker, as a firm, to represent clients that you've always had. You can enter into an agreement to represent their interest in a fiduciary capacity. How that agreement plays out may look a little different. The focus of the settlement has been on transparency, disclosure, the ability to negotiate commissions, which, by the way, we've always had. But the focus is emphasizing the negotiable nature of commissions. and having things in writing. That won't change. None of that changes. What changes is there may be some instances where a seller says, I'm not willing to pay a buyer agent commission. And in the past, they may have not been so fast to say that. It could be the case that they say it more. We don't know. We do not know how this plays out ultimately from the buyer and the seller's perspective. Think about it. The seller wants to sell their home. The buyer wants to buy a home and they want to get the best terms that they can possibly get. That is why, historically, brokers have been involved in transactions. If you look at the statistics, overwhelmingly, year after year, buyers and sellers say, through surveys and through their actions, we want the help of professionals. That's why they hire firms and brokers to take care, and agents, licensees, to take care of their interest in a transaction. That's why the industry exists. So the ability to negotiate, the ability to represent clients, that does not change. The how may shift a little bit. Does this settlement change disclosure rules? The short answer to that is yes, depending on where you are. Different states operate with different disclosures. But this settlement will now require all realtors to disclose certain things regarding commissions in a unified manner nationwide, most notably that they will not be offered through the MLS to buyer agents, that they must be in writing before touring a property. If you live in North Carolina and have operated in real estate in North Carolina, again, I'll reiterate, this may not feel all that different in terms of the disclosure requirements that you've had historically. In some other states, it will feel very different if this gets to final approval because other states operate very differently than North Carolina. Missouri operates differently than New York. New York operates differently than Pennsylvania. Pennsylvania operates differently than California, and so on and so on. This will make a more unified approach to how compensation is advertised and offered to competing interest in a transaction from a brokerage standpoint. Common question number 3 that we've been getting is, can a seller still pay a buyer agent commission? And overwhelmingly, I hope you take away from tonight, yes. Yes, 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 and yes. The seller can absolutely still pay a buyer agent a commission to bring a buyer to purchase their home. And I think you will hear a lot of listing agents make an argument to their sellers for why they should at least consider doing that. Will they force a seller to do that? I don't think so. Will they try to present a rationale for why they think that may be a good idea in the process of selling their home? I imagine you'll hear those arguments articulated a lot from listing agents. Now, you may say, well, if I can't offer on MLS, what's the point? There's a lot of places that things can be offered outside of MLS, my friends. There's personal websites, and I'm not advising you what to do here. There's all kinds of places. There's phone calls, there's emails, there's third-party sites. There's all kinds of things that could potentially play out here. We're just strictly talking about the member-based site that realtors are attached to. That has been the concern that this settlement has tried to address. But yes, absolutely, sellers can, and most likely, call it an opinion if you want, will pay buyer agent commissions in a lot of instances. Number 4, we've touched on this already, but it's worth reiterating because as strongly as I emphasize point number 3, I equally want to emphasize point number 4. Is this a done deal? The answer is no. It is currently on track, and especially based off today's information about preliminary approval, it is currently on track and on the timeline of NAR's hopes within the settlement to reach approval. That doesn't mean it will reach final approval. And again, depending on who you ask, that it will and when it will, but we don't know. We flat out do not know. And anybody tells you for sure that they know, they are lying to you because they don't. They can make an assumption, but they don't know. And so hopefully you take that away from tonight. We don't know how this finally plays out. And I was talking to Frank, who's done such a good job of spearheading these discussions on behalf of Superior. And we were talking offline and said, we're probably going to have some follow-up conversations and offer more sessions like this as the approval process goes deeper, because things may shift. New details could get added. We don't know. We don't know what the final approval looks like. And as final approval goes along, I imagine you'll be hearing from us about, hey, you want to jump on again? We'll be happy to discuss what we know in real time, because we're in real time today, and we don't know what real time looks like in July, August, November yet. Question number 5 we've received. Can I put into the MLS comments about paying commissions, even if I don't list a single number? Can I use code language to somehow send an incognito signal that I'm willing to pay? Can I put a wink emoji in that says, hey, buyer agent, look over here, we'll pay in the MLS? The answer is no. If the settlement plays out, you can't do that. But again, there's no prohibition against communicating such concessions off of MLS. Let's look at one final question that we've commonly received, and this may be the most important common question we have gotten, and that is this: will this end the real estate industry as we know it? Now, I can only offer you my opinion on that, but I will tell you as emphatically as I can in terms of an opinion that the answer to that is no. It will not end the real estate industry as we know it. Will it require some changes? The answer to that is most likely. Will brokers and firms potentially have to get creative in how they go about the business compared to how they've done it in the past? Perhaps, if not most likely. Will it cause home prices to plummet? Again, a John opinion. I don't think so. I'll tell you this: I've seen a lot of home builders already saying, we'll pay buyer agents. The day this got announced, the initial settlement agreement got announced, if you paid attention to the stock market, a lot of home builder stocks went up. They didn't go down. They anticipate this will actually help certain aspects of the industry. Now, where this becomes a potential challenge, and I've said it so many times, I keep on reiterating, this is John's opinion talking here. It will likely require, if you're a broker that is in the practice of representing buyers' interest in a transaction, I do think at the least it will require you as a buyer agent to take a fresh look at how you articulate your value-added proposition to a transaction. And that articulating aspect may have to come in the form of how you articulate that to a buyer. Because if you've got a scenario where you call a seller, and this could have happened at any point, by the way, up until now, it may not have happened as commonly as we may have assumed, but it could have happened for sure. It definitely could have happened in the scenario I mentioned about the for sale by owner. You call and you find out that the seller is not willing to pay a buyer agent commission as part of their transaction. And the buyer says, well, I want you to represent my interest, though. You're going to have a not an argument, but a here's why you should hire me talk. Here's why I am worth the money. I believe I'm worth the money that I plan to charge for representing your interest in this transaction, dear buyer. Here's why I think it's a good idea for you to do that. And you have to make a decision, dear buyer, whether or not you agree with that assessment. I think buyer agents in particular are going to have to do a really good job of articulating their value-added proposition to a transaction. Equally so, sellers are going to have a really good understanding of, dear seller, here's what I think the best approach is to selling your property. Different brokers, different firms, different brands are going to take different approaches to that conversation. You're going to have to be aware of that in the days ahead. Everybody's going to take a potentially different approach to what this looks like moving forward. Is the industry going to die, though? I do not believe so. I have been in it for 20 years now. Some of you, if not many of you, were around in 2008, and everybody said, it's over. Game over. We're done. Guess what? Here we are. Buyers are buying homes. Sellers are selling homes. Hadn't changed. Interest rates are skyrocketing. Buyers are buying homes. Sellers are selling homes. The market crash. Buyers are buying homes. Sellers are selling homes. And by and large, they're enlisting the help of licensed professionals to help in that endeavor. How that looks, what that works out to be in the days ahead, it may change a bit, but it doesn't mean that the industry is over by any means. So those are some of the common questions we've gotten. Let me pull up our Q&A here. Hopefully you've tracked with me. We're right on target for 45 minutes, wrapping up the actual presentation. So let's look at some of the questions that we have, that we've gotten. Could you address the changes of how referrals are to be handled? Great question, Mark. Thank you for asking that. I don't anticipate that referrals will change a ton, other than I imagine the agent receiving the referral is going to have to cover their bases to say, I can only guarantee a referral in the amount that I am compensated from the buyer or from the seller. So there will probably be some type of a, let's call it security blanket for the agent receiving or the firm receiving the referral, I would imagine, to say, if we don't collect X, we're not paying Y. So in the past, where we've had a traditional model that referrals were most often, not exclusively, but most often a set percentage of a commission to be received, it was with the assumption that a commission was going to be collected. Well, now what happens now if you Mark sends me a referral and Mark says, I want 25%, and it turns out that I get a flat fee of $500 to handle the documents on this case. Am I going to be willing to pay 25% of my $500? Maybe the answer to that is yes, maybe no, but there may be some more negotiation even on the referral front for how that plays out. We don't know quite. That's a very astute question, and one I haven't honestly thought about a whole lot to date. Does the July date for no concessions MLS stand even if the settlement is not approved? Thank you, Susan, for the question. My understanding of that is yes. Those changes are going to be enacted because there's concerns about future exposure. From what I understand, should changes not take place, given the nature of some of the lawsuits that have been coming up over the last several years. Whether you believe that's justified or not, or whether I believe that's justified or not, is not really relevant, but those are action steps that NAR as an organization and a lot of the membership companies are planning to take. How do you think the commissions will be communicated if not on the MLS? Great question, Meredith. Thank you for asking. I envision several different things. I envision, like I said, direct communication between agents. That could be text messages, phone calls. Most agents are going to want to have it in writing that they're expecting to get paid something. So it could be emails with forms attached. Please fill out the form confirming that I will be paid X if I bring an acceptable offer to the table. It could be in the form of third-party websites that we're not aware of yet. We don't know. It could be in the form of services that are currently existing that maybe weren't part of this whole MLS structure to begin with. We don't know, but it will be in a lot of different ways. And it remains to be seen what, specifically online, what sites are going to be willing to engage in the, let's call it advertisement or promotion of commissions from sellers to buyer agents. But I do think you're going to see some new ways that that's done in the past. Can services like showing time not only state days, hours of showing opportunities also, but show compensation offers? Thank you, Mary, for the question. I want to be very cautious how I answer that particular question because I have heard candidly some discussions about some of the vendors. I'll mention the vendor that was mentioned there that says, oh, they'll be able to advertise it, or they're going to plan to show it. I don't think I can provide a definitive answer on that. I imagine those discussions are taking place internally, but you have to keep in mind a lot of those services have an attachment to MLS in some form or fashion. And so I imagine that MLS is asking their attorneys, what about the parties that we have vendor relationships with? I'm not an attorney, so I can't answer how the attorneys will answer that question, but I promise you it's a question being asked. as it pertains to third-party vendors that are not the MLS itself, but have some type of MLS attachment. Again, a question I'm sure attorneys are working through and that I cannot give a firm answer to yet, but we'll probably know more about in the days ahead. Can we put the commission amount on a separate property website and have a link to that website in the remarks, both public and agent MLS? Thank you, Jennifer, for the question. I don't know the technical answer to that, if they would view a third-party link as an advertisement. I know you're not allowed to put it, according to the settlement, in the MLS itself or anything about comments about it in the MLS itself. I'm not sure if that results in no one-click away link to that information. NAR currently has what's called the one-click rule as it pertains to, if you're one click away from a firm's name, that's permissible in advertisement. If you're in North Carolina, we don't share that rule because our real estate commission says the name of the firm has to be on every advertisement that the firm is associated with. Okay. So I don't know if there's going to be like a one-click rule that MLS is permitted to have. As a result of this settlement, that may be part of the discussions that the attorneys are having, even to this day. Had an anonymous question, said, if sellers offering 3%, pardon me for getting close to the screen, my eyes aren't great right now, but sellers offering the buyer's concession, and we note that in the MLS, could that signal that seller is open offering commissions? Maybe. During negotiations, maybe the concession turns into commissions. I'm envisioning a way to maybe signal to buyer agents that sellers are open to commissions. Could be the case, I'm not sure. Although I would say that my suspicion is, and this again, so much of this is operating on assumptions or guesses right now. My guess is that MLS systems are going to be pretty aware about potential dangers with such things. You have to envision when settlements happen, whether the settlement indicates, keep in mind, NAR and other parties that are in the settlement, none of them are admitting to any wrongdoing with this stuff. There's never been an admission of, hey, we did wrong. That's not what's taking place here. That's not how this settlement works. The settlement is saying, to settle this out, to end this, here's what we're proposing. And typically with what I've witnessed with settlements is that even if you're not admitting wrongdoing, you want it done. And so I'm just a guess here, just hypothesis, that parties involved in the settlement, that extends to NAR, MLS systems impacted, companies impacted, they will probably err on the side of caution, if I had to guess, as it relates to how this stuff could be viewed in the eyes of the public or the law, such that they don't have any challenges to how the settlement plays out in real time. So I would be cautious with the thought of kind of like, is there a way to work around it with signaling, because I could foresee that there will be a lot of attention paid to that. What helped me out in the perspective of MLS is simply an advertising tool. Buyer commissions cannot be advertised in MLS, but can be disclosed via other advertisements. Yeah, you are. Again, that's a correct line of thinking. What you've got here is nobody is saying that a seller can't pay a buyer agent. Nobody's saying the seller can't advertise that they'll pay a buyer agent. What they're saying is that within the exclusive model that the MLS system operated as, where you had to be a member of NAR to have access to this MLS system, where these commissions were being offered within the membership, that's what they're trying to negate at this juncture. I saw something about one of the changes. We cannot receive more compensation than what's buyer agent. Can I just change my agency agreement? Yes, you will need to, Jennifer, thank you for the question. You will need to indicate in writing at some point in your buyer agency agreement, as far as I understand it, exactly what the expectation of compensation is for that transaction. So if in your initial buyer agency agreement, you said, I'm going to collect 3% on this transaction. I'm going to seek it from the seller. If the seller won't pay me, you're going to pay me the difference. And the buyer agrees to that. And then it comes out that the seller will pay 2%. And the buyer says, I'm not willing to move forward with this transaction on our original 3%. That's just, it throws me over the margin. Will you be willing to take the 2% the seller is willing to offer you? And the buyer agent says, yes, I'll reduce it to 2% with my firm's approval or whatnot. And that's where they land. That would need to be reflected in writing somewhere that the buyer is not on the hook, so to speak, for that extra 1% compared to what the seller was willing to pay through their advertisement. Where's the settlement money coming from? Will the members be assessed for it? Linda, great question. I cannot confirm nor deny where that money is going to come from, although I will say they have 4 years to pay it. And I don't know if it comes in the form of loans. I don't know if it comes in the forms of rate increases. I'm not sure, but they have 4 years to pay the $418 million in settlement. So are we going to start actually practicing this in July before the final settlement? The answer to that is yes. These changes should go into place in July. If you've heard, what is the logic behind not being able to show commissions offered in MLS? Brian, thank you for the question. That's been the whole question around this settlement and lawsuit to begin with, is that the premise of a seller, I'm going to be very careful how we word this, because no party in this settlement is agreeing to any wrongdoing at all. The accusation has been that a seller has basically not had the freedom to negotiate the ability to pay a buyer agent commission. John's opinion, that's not accurate, but that's been the accusation. And so the part of the settlement is NAR and other entities saying, hey, we'll just take it off MLS then. That's the concern. We will remove that from MLS such that it is not viewed as you have to be a member of MLS to see exactly what's going to be getting offered, which is why you're showing the house in the first place. What does this mean for appraisals? Thank you, Lisa. I've talked to several appraisers, excuse me. I've heard mixed reports. I've heard some appraisers say this will not impact appraisals at all. I've heard others say it could potentially have an impact on appraisals. We just don't know until that plays out. Where do you look at for the compensation then, Priscilla? Great question. You're going to have to contact directly or use where other sources where it's going to be advertised. Is there a risk to using other ways to communicate? Seller once. Great question, Kevin. My understanding of the settlement is that this insulates NAR, members of NAR, MLS systems in a manner that they are free to communicate. They're just not free to communicate via MLS, via the MLS system. So I don't, hey, people can sue for anything. But I do believe the settlement, if it goes to the final conclusion, would offer certain protections that we have not previously had prior to the settlement. Listing through a showing service, can that compensate? We talked about that one, Joe. Hopefully you heard that answer. That's the question related to showing time. Can there be an unrepresented buyer if they don't want to pay a commission? Yes, there absolutely can be an unrepresented buyer. And the unrepresented buyer could flat out go in that they could say, I'm not representing. I don't have an agent representation. Think about new construction. A lot of new construction properties are sold without a buyer having agency relationship on their end of the equation. And the representative of a builder would say, just so you're aware, I represent the builder's interest in this transaction. I am serving as the listing agent. You have the right to have a buyer agency agreement in place, but you don't have to. It would be very similar in practice to that. In the real world, you may have buyers that choose to go at it alone. And they could even choose to ask for a reduction in price, I suppose, on account of going at it alone, although the seller can also in turn say, well, it has no bearing on what I'm asking for our property. Terry, the great Terry Wilson, who I would probably been the better person to present this other than John Walker, said, remember, you will all need your BIC's approval before agreeing to any kind of compensation from the buyer. That is 100% factual information. And as always, it's so great to have mentors like Terry here to keep me in check and make sure that I cover and cross the T's and dot the I's. Do you expect a confirmation of compensation to be included with all offers? Cam, conjecture, I would imagine so, but that is just conjecture. will clear cooperation go away that is currently requiring all listings to go into MLS? Angela, I cannot confirm or deny that. I have not seen that as an aspect of the settlement. Showing time's owned by Zillow, so that seems to be a questionable place to offer compensation. I can't speak to Zillow's involvement to this, but I do understand the perspective. Yes, they are a member of a lot of MLS systems now across the country. Does the ruling prohibit uploading a signed compensation agreement from a seller? I believe it would eliminate the possibility for that, as best as I understand the settlement. But again, I'm not an attorney and can't speak to the legal nature of that. What do you see the conversation with a potential calling off a sign, for example? I can't imagine that wanting to sign a buyer. Well, yeah, great question about how do you envision these calls going? It's probably going to take some time to fill those out, honestly. None of this is going to get worked out instantaneously in terms of how it plays out in real time. It's going to take some time to figure this out. You may have similar. It's not all that dissimilar group to today. You have some buyer agents today that will not show 1 inch of a property unless a buyer signs a buyer agency agreement with them first. You have other buyer agents who are more than willing to operate on an oral buyer agency agreement to show property and reduce that to writing before writing an offer. There's a spectrum of approaches to how those conversations go. This will introduce a new spectrum of approaches to how those phone calls go initially for saying, well, here's how it works. Just so you understand agency in North Carolina, here's how compensation works for agency or whatever state you're located in. And those going to take some time to work out. Buyer agent question really was, if I have an agreement for 2% and they pay 3%. Great question, Jennifer. I'm sorry for misinterpreting the initial response. If the seller offers 3%, let's say, and my buyer agency agreement is 2%, there is nothing that says you cannot accept 3% if the client approves of it, but you would have to get client approval. It's similar to today, to where if you have a buyer agency agreement in place for 3%, let's say, and a home builder is offering you an extra bonus if you sell a house during the month of May. There's nothing that says you can't accept that bonus so long as it's approved by your firm and approved by the client. Similar structure. You can get paid more than the original as long as it is approved and in writing. Explain the difference again if your local association is owned by NAR or not. Thank you for the question. Some MLS systems are owned by NAR and some are not. The MLS systems that are owned by NAR, they will automatically be roped into this settlement agreement. The MLS systems that are not owned by NAR but participate as a member participant with NAR will have the option to opt in, as far as I understand, from the settlement and be included in the protection that the settlement offers. Can the compensation be included on showing time? Thank you, Deborah, for the question. We don't know yet. How do we know if our MLS or our firm is under NAR umbrella or protected? You can ask your MLS if they're a member-owned, NAR-owned MLS system. We got time for probably 3 or 4 more questions before we wrap up. Will the buyer pay commissions from loan amount for the property or out of pocket? That's a great question, and it's going to depend on how lenders work with these new regulations. For instance, right now, a big question a lot of people have had is, what about VA loans? Because right now, VA loans are not allowed to pay VA borrowers not allowed to pay their buyer agent commissions. How does that factor in? And there's ongoing discussions about how that gets ironed out, if it gets ironed out, should this go to final conclusion. But the lenders are going to have to play a role in how these discussions go about what the buyer is potentially coming out of pocket for. Can it be roped into financing or not? Does that hurt the value of the loan? How does that all play in? That's all coming down the pipeline. Comment that came in: lawyers faced these issues in fixed fees 50 years ago and have gone broke since. That is, fee schedule is prior to their settlement. I can't speak to how that's played out over time, but I definitely hear you on your perspective there. How do you think this will impact multiple offers? Ooh, that's a good question, Arlene. It depends on a lot of variables, which I want to be cautious how I answer that. It's impossible to blanketly answer that yet, but I will say it depends on variables such as, has the seller agreed up front and advertised to other buyer agents, hey, we'll pay your fee, such that buyer agents know going in that the seller's willing to pay something. And everybody has to keep in mind with this too. I think there's been this operating assumption that if a seller advertises that they're paying a buyer agent commission, that it's going to be an exact amount that everybody's familiar with. You could have a seller, just like they always could have said, we'll give a buyer agent $100 to bring us an offer. We'll give a buyer agent a 0.5%. We'll give a buyer agent 10%. It always could have been like that. But we've operated in this world where competition, and I believe it was competition driven, no matter what anybody accuses. I believe it was competition driven that said a lot of brokers would say things like, I'm comfortable receiving X percentage. We don't know what a seller's going to be comfortable paying. Is it to scale on the price of a home? Is it going to be that sellers get more comfortable with a fixed rate model or percentage? We don't know. We just don't know how that's going to translate. All right, last question we'll take from Angela, and then I'll leave with a closing thought here. Most of us have a video web link in the MLS. Would we be able to advertise the commission within the link, or does that go back to the link in general comment you made earlier? My suspicion, Angela, is, again, strictly a suspicion, that would be viewed as making a comment within the comment section of the MLS because it was linkable to the comments. But that, again, is only an assumption. That may not be part of this that is prohibited. I just don't know how they're going to settle out. Those are particular types of questions that I'm sure will be addressed as they go towards, if they go towards final approval. I want to leave you with how I started. Things have changed, things are changing, and things will continue to change. When this settlement is done, whether it is approved or not approved, guess what? Next year, the industry will change. It's just going to happen. And the settlement may get approved. It may not. Whether it does or doesn't, the industry is going to change some. Brokers are going to be tasked with adapting. Firms, brokers in charge. New licensees are going to be tasked. MLS systems are going to be tasked with adapting to changing conditions on a consistent basis. This is no different than that. I will admit, I've been in this for 20 years. I will admit this feels a bit more seismic in nature than that's no big deal. It kind of feels like a big deal. It feels like a big deal moment that we have to consider. That's why we're having a webinar on it tonight. But it doesn't mean those are waters that cannot be navigated, and even navigated smoothly and with potentially great results for the brokerage community. It just all depends on how we respond. And so I hope that this has been helpful for you tonight. I hope it's cleared up a few cobwebs, if there were any, about what the settlement is, what it involves, some of the common questions we've received, and what may happen next. It's been a real privilege to be with you. Hopefully, we'll see you at a future webinar or a future class that Superior School of Real Estate hosts. We count it a privilege that you entrust us with this information, and you entrust us with helping you understand things that are pertinent to your business and potentially your livelihood. So we wish you all the best. Thanks for being with us tonight, and we look forward to seeing you here in the near future. All the best to you.